Hi everyone, my name is Jennifer Smith Gray and I'm going to be presenting on the topic of the Students First Act of 2011. I do appreciate your time and consideration during this presentation. Let's get started. The Students First Act, when it was developed and by the legislatures, they did have a few things in mind. The purpose of the Students First Act of 2011 was to assist in improving the quality of education. As part of that improvement, it did identify boards as being the authority and the responsible party for employing competent educators. And it also sought to improve student achievement through the allocation and hiring of those competent personnel. It also has the purpose to ensure fairness and to provide due process to those employees. Another purpose, to ensure the effective use of limited finances. As we know, many systems do struggle in this area, so the Students First Act, the legislatures did hope that this would help. It also has the purpose to simplify the process when legal challenges do occur. The Students First Act of 2011 did replace arbitration, which was used in the Fair Dismissal Act of 2004. Legislatures did hope that by introducing this piece of legislation, that it would help to reduce the financial cost of litigation by not only the school systems, but by the employees themselves. Who is covered under the Students First Act? All certified personnel that are full-time and all full-time classified personnel. Now let's define classified. Classified personnel refers to your bus drivers, your CMP workers, custodial or maintenance staff, clerical staff, instructional aides or assistants, and your non-certified supervisors. It does not cover employees covered by the state merit system or your part-time employees. A part-time employee is defined as an individual who works 20 hours or less per week, so those individuals would not be covered. Your superintendent and your chief financial officer are not covered under this particular act. What is protected? Protection and status as a tenured teacher or a non-probationary classified employee. That is what is protected. It protects the job, not the job title. And let me give you an example of that. Let's say that I have an individual who is my attendance clerk. She is tenured as a clerk, and I decide to move her to my guidance office to be my guidance receptionist. It protects the fact that she has a job, does not protect that job title. In other words, she does not have a right to remain as an attendance clerk just because she is tenured. So, let's look at non-renewals and termination in regards to the Students First Act. Before I jump into this, however, let me make some clarification here. You'll see in the PowerPoint that I use the terminology of tenured, non-tenured, probationary, non-probationary. Those are interchangeable. So let's look at non-renewals for probationary individuals. These are individuals who are non-tenured. These individuals, if they are being non-renewed, they must receive that notification in writing. That notification should be given to them on or before June 15th. The decision for the non-renewal cannot be personal or political. Now, how long does an individual stay in probationary status or non-tenured status? The probationary period is 3 consecutive years of full-time employment as a teacher. The employment period is defined as on or before October 1 and until the end of the school year, basically the end of their contract. termination for a tenured and non-probationary personnel, they must also receive the non-renewal in writing, but they must receive it within 10 days of the board's vote. And this is because they do have the right to a hearing. The employee can request a hearing within 15 days of receiving that notice. And like non-renewals for probationary individuals, the decision for non-renewal cannot be personal or political in nature. Non-renewals and termination for those tenured individuals. Just a few minutes ago, I said they have the right to request a hearing. If they do request a hearing, during that hearing, it is the superintendent's duty to bear the burden of proof. The employee does have a right to legal representation. Both sides do have a right to present evidence and witnesses as to why they feel that they are right in this decision. Proceedings are recorded by a court reporter, and the hearing may be public or private. The decision on which one it is does fall on the employee. After the hearing, the board has 10 calendar days from the date of the hearing to release their vote. From that point, the employee does have a right to appeal. This appeal actually goes to the State Department of Education, and it must be made within 15 days of the decision. The appeal at that point is heard by a panel of 5 retired judges. Their decision must be rendered within 5 days from that hearing. At this stage, both parties have the right to an appeal. That appeal would actually go to the Alabama Court of Civil Appeals. Reassignments and transfers. Reassignments. These can be made within the same campus without the loss of pay and with no appeal. Tenured teachers may request a hearing, and they must be given notice within the first 20 days of class of that reassignment. Certification must be appropriate for the reassignment. For example, I could not take an individual who is only certified in science and place them in an English class. That certification is not appropriate. This can only be done, reassignments can only be done during a school year for a teacher. Transfers for those tenured employees. Transfers are governed by the same rules as reassignment, but written notice must be given within 15 days of the decision. Tenured teachers are governed by the same rules as reassignments, except they have the opportunity to meet with the board. If the transfer is outside the high school's feeder pattern, the teacher can request a hearing. Now, let me explain feeder pattern. Larger systems that have multiple high schools have a feeder pattern. In other words, my high school, because we have 5 other high schools in my system, we have a feeder pattern that consists of 5 elementary schools and 2 middle schools. So that's what that's referring to. Probationary employees can be transferred even if it results in a cut in pay or a reduction in contract. Termination and certificate actions. Non-tenured individuals can be terminated at any time within the school year, but they must receive written notification within 30 days. Non-tenured personnel can write a statement explaining why the action should not be taken. That written notice of termination, remember, must be issued. Non-tenured individuals have no right to an appeal. They also they do not have to be given a cause for that termination. Tenured individuals, however, can only be terminated for the following reasons. Justifiable decrease in the number of positions, and we will discuss that in more detail in just a few minutes. Incompetency, insubordination, neglect of duty, immorality, failure to perform duties in a satisfactory manner, or other good and just cause. Notice must be given in writing, and the notice must explain the appeal process and must include reasons for the proposed termination. Suspensions. Employees can be suspended 20 days or less, and they only have the right to appeal to the board. There is no appeal beyond that. They must receive written notice with reasons outlined for the suspension. If the suspension is going to last 20 days or longer for tenured personnel, they would follow the same procedures as a termination. And finally, partial cancellations and reduction in force. These must be prospective, and this is based off the superintendent's recommendation. These recommendations of reduction in force must be approved by the board, and it must be a result due to decreased enrollment or a financial shortage. It must follow the reduction in force policy that the system has in place, and it must be applied to all employees. In this particular situation, employees have no right for a hearing request or for an appeal. This concludes my presentation on the Students First Act of 2011. I do appreciate your time, and I hope you have a great day. Thank you.